A simpler guide to alternative dispute resolution.
We present that encouraging self-represented litigants to engage in alternative dispute resolution would be an area of civil procedure that would majorly benefit from reform. Legal proceedings are scary, and the average person will often feel immediately overwhelmed, especially if they're unable to obtain legal advice. Other jurisdictions offer online guides that the public can access. However, the information contained may not be directly relevant to self-litigants here in South Australia. Currently, the Family Court of Western Australia offers booklets for unrepresented litigants who are parties to cases involving children and/or property. These existing booklets are onerous to users as they are often complicated, lack the use of plain English, and are approximately 50 pages long. It's for this reason that we propose to create a booklet detailing the methods of alternative dispute resolution that is significantly less lengthy and more comprehensive. This will be less intimidating for self-represented litigants who are highly stressed, confused, and frustrated. These booklets will aim to reduce the amount of matters that progress to trial, which would prove cost and time effective for both litigants and the courts. These booklets can be provided upon pre-lodgement of a claim or originating application in any court if the litigant indicates that they are unrepresented. Despite a lack of empirical data, it is nationally accepted that the numbers of self-represented litigants are rapidly increasing each year, which is concerning because many self-represented litigants are significantly disadvantaged during legal proceedings compared to trained solicitors. The National Council of Single Mothers and Children represented that in 1999, the Family Court reported that 81% of self-represented litigants would benefit from legal representation, 75% of people would have benefited from their opposing party being represented, and 80% of cases involving the interests of children would have benefited from legal representation. It can be assumed that this percentage would be similar would have likely increased in the years since due to the restrictions on legal aid funding and the growing numbers of self-represented litigants. Currently, South Australian magistrate courts administer physical booklets created by the Legal Services Commission which demonstrate how to recover debt in a streamlined step-by-step methodology. This booklet has significantly increased the number of mediations that are held in the magistrate courts, which has reduced the number of debt recovery matters that have progressed to trial. As previously stated, the Family Court of Western Australia have created extensive booklets for self-represented litigants who are parents in litigation matters and those who are involved in property disputes. These booklets outline how to prepare for a trial and the relevant law for each type of matter and a description of the trial process. Such a booklet also exists for unrepresented litigants who wish to pursue action in the civil jurisdiction of the Magistrates Court of Western Australia. Although statistical information cannot be found, it can be assumed that such guides have assisted self-represented litigants in understanding the fundamentals of court procedure and would therefore reduce the amount of matters that have progressed to trial. Unfortunately, however, not all people have access to the internet or a computer, which is why we propose that creating a clear, informative, and digestible booklet that can be physically distributed would be highly beneficial for many self-represented litigants. We propose that creating a similar booklet that demonstrates a number of methods of alternative dispute resolution and which methods suit different types of matters will yield similar results. This will encourage a transparent framework that will aid unrepresented litigants to practically recognise their rights and responsibilities while also offering the court and the registry a formal guideline on how to advise unrepresented litigants on the basics of legal procedure. This booklet will be a succinct and digestible version of the Attorney General's Guide to Dispute Resolution, which is a 41-page electronic document that was created by the National Alternate Dispute Resolution Advisory Council. Due to its comprehensive nature, our booklet will have the potential to yield similar results as Queensland's currently implemented supervised case list, which has improved the success rate of unrepresented litigants to 28% compared to 11.4% in the previous year. Furthermore, equipping self-represented litigants with knowledge and understanding of alternative dispute resolution processes would be financially beneficial as proceeding to court can be extremely expensive, with even the lodgement fees in many jurisdictions costing thousands of dollars.
This booklet will be accessible from all registry counters across the Higher Court and Magistrates Courts of South Australia, as well as the Court SA website. This will provide a wide range of accessibility to self-litigants and hopefully answer a range of questions that self-litigants may initially have. While improving efficiency, this will also increase the capacity of Court SA staff and therefore waiting times to resolve questions.
A few things we considered important to keep in mind when creating the booklet was not only the use of simple language and extra resources where applicable, but also stylistic features such as the font size, the way information was presented on the page, the use of bullet points where possible, and clear headings. A common trait amongst legal resources and other documents are that they are often hard to follow and contain many words, often in fine print, and not many visual aids such as flowcharts. For many people, a document might be overwhelming before even attempting to read it, just at the sight of the exorbitant amount of words on the page. For that reason, we have aimed to keep our booklet as simple and straightforward as possible, not only in the language, but also visually. Additionally, the online version of the booklet will be hyperlinked where appropriate. For example, as you can see on the screen, the glossary may contain links to legislation which occasionally are hard to locate for the average person.
Our booklet will aid in common processes that self-litigants are left to navigate on their own. One of these processes includes discovery. Discovery is a process that occurs during pre-trial stages. Discovery is acknowledged as a process that encourages efficiency by allowing a factual analysis of the issues at hand and develops an accurate appraisal of the facts. This often leads to faster settlements. Discovery can, however, be a difficult process to navigate for self-litigants. What is a relevant document? How do I find and use a Form 73A? Do I need to provide original copies during discovery? These are all valid questions that are often taken for granted by people with legal knowledge. Our booklet will provide a step-by-step, easy-to-follow summary of the discovery process using plain English and examples where appropriate. This guide will improve the efficiency and accuracy of discovery. We believe that if executed well, there will be a reduced need for further discovery orders to be made.
By really breaking down various concepts relevant to alternative dispute resolution in this way we just described, we hope that self-represented litigants better understand the processes involved and make fewer mistakes and optimise their chances of reaching a solution out of a traditional court setting. There are many different types of alternative dispute resolution. It can be confusing as to what options a self-represented litigant may have or what might work best for them. Alternative dispute resolutions are not something that the everyday person may discuss, and therefore the language used, as it is with most other legal documents or resources, are difficult to understand and follow for average people. To maintain simplicity, our booklet will contain descriptions of only the most popular forms of ADR in South Australia, which include mediation, arbitration, conciliation, neutral valuation, facilitation, and settlement conferences. On the screen now is an example of how we will condense an overview of alternative dispute resolution as opposed to how it currently appears in the UCR. Each of these methods of alternative dispute resolution will be discussed and explained throughout the booklet. For example, on the screen is a page for mediation. The page, along with any other descriptive page, will include a short and easy description and a bullet list of all key features. These pages will also contain reference to relevant legislation, as well as to any documents and forms which might be required as part of the process. For those forms of alternative dispute resolution we choose not to include in our booklet, we will instead include various recommendations to other publications such as the Attorney General's Guide to Alternative Dispute Resolution or to various websites such as a law handbook that may instead provide better guidance for points that the booklet does not cover.
We believe that our booklet will be extremely useful to self-litigants that are trying to navigate the legal system on their own. This booklet will provide the foundational framework that self-litigants need to be able to understand and complete legal tasks. It will increase the efficiency of the courts by informing and suggesting alternative dispute resolution methods early on and will relieve some of the pressures on court staff by reducing the number of queries received. This booklet will also educate self-litigants and ensure less confusion and fewer mistakes occur. Thank you for taking the time to hear our presentation.